Evidence Part 1, looking at the introduction of evidence. Court is not bound by the rules of evidence except as to privilege. An objection is only for admitted evidence. That objection must be timely and state specific grounds for the objection. An offer of proof is for excluded evidence. So if you try to admit evidence that's excluded, you can make an offer of proof. That offer of proof is an oral and or written explanation of the relevance and admissibility of the evidence. Evidence may have limited admissibility, such as the court may restrict the scope of evidence, such as against one party, but not against another. The completeness rule of evidence. If the plaintiff offers evidence, such as a document and or recording, the defendant may compel the admitted or omitted portion in the interests of fairness. Looking at judicial notice, court may take judicial notice of facts where there is no reasonable dispute to that fact because that fact is generally known. Looking at cross-exam, cross-exam is limited to the subject matter of direct and the credibility of the witness. So the subject matter of the direct and the credibility of the witness may be investigated on cross-exam. Discussing some objections. And again, objection is for admitted evidence, must be timely and state specific grounds. Leading. Leading is not allowed on direct except to elicit preliminary background information. Leading questions are, however, allowed on cross-exam. A leading question is a question that suggests the answer within the question, such as, isn't it true that you're from Duluth, Minnesota? Compound questions. A compound question is one question with multiple parts asking for one answer. An example would be, did you wake up this morning, go to the gym, kill your wife, go to work, and come home? An objection of assumes facts not in evidence. Assumes, this objection is a result of assuming as true facts that have not been established in a question, such as, when did you stop beating your wife? It has not been established that you beat your wife. It assumes that fact. The objection argumentative. This is when a question is intended to provoke an argument, such as, do you really expect us to believe you? The objection of calls for conclusion and or opinion. This objection is addressed when a question asks the witness for a conclusion and or opinion that the witness is not qualified to make. The objection repetitive is used when re-asking a question that has been asked and answered. Looking at the burden of proof, the burden of proof consists of the burden of production and the burden of persuasion. The burden of production is the burden to provide evidence sufficient to establish each element of a case. Burden of persuasion in civil litigation is a preponderance of the evidence, meaning anything greater than 50%. Burden of persuasion in criminal litigation, criminal prosecution, is beyond a reasonable doubt, and that's from In re Winship. A presumption is a conclusion the jury is required to draw upon. It's an underlying fact, a basic fact. It might coincide with judicial notice. A rebuttable presumption may be overcome by evidence to the contrary. This shifts the burden of production. Destruction of evidence. Destruction of evidence raises a presumption and or inference that that evidence that was destroyed would have been unfavorable to the destroying party. And that concludes part 1 of evidence.